All right, my friend, I believe we are live. So I am seeing Steve by video, which is how I've always known you before. But the past few days, we got to meet in person. So that was fabulous at CreditCon.
We did, yes. Welcome everybody to this week's edition of Legal Ease with John Watts and Stephen Palmieri. And I am just trying to recover my voice because John and I were at CreditCon, Clearwater, Florida. And I definitely am not hungover, but I'm hoarse because of all the partying. And we had the cruise boat that went out on the sunset, and then the party on Tuesday night was wild, like just yelling and screaming. So we're going to try to squeak our way through this show for you guys. But those of you who are joining us live, obviously comment your questions and stuff below. We're doing this for you guys. So yeah, John, we got to meet each other for the first time in person, and you are as advertised. You're just as good looking a guy in person as you are on this live stream. You know that. So it was kind of the brain trust down there. I mean, there were like a whole bunch of attorneys in, kind of hanging out in there. And so, tell us about that. Did you get any good nuggets of information? What did you learn from the other FCRA attorneys? Give us your recap of CreditCon, man.
Yeah, there were great conversations. And I'll say this, if you're in the credit repair space, if you are a lawyer doing what we do, which is sue debt collectors, sue credit bureaus, it's a really neat place to be. And the content of the speeches, presentations, that was good. But it was, I would say predominantly the meeting other people, making connections and learning, hey, what do you guys do over here? What do you do in this situation? And that was really, really good. So it was great. Very good.
Yeah, the networking aspect. Go ahead. Yeah, sure.
Oh, I just got to say, has Matt released when the one will be next year?
Absolutely. Yeah, he's already got that. So next year's CreditCon, which, by the way, for those of you guys who are interested in learning more, it's a credit-con.com. That's Matt Listro. He hosted. It's going to be in Las Vegas, April 11th, 12th, and 13th. I think those are the dates. It's Monday, Tuesday, Wednesday, April 11th, 12th, and 13th. He's got it set up at the Paris Hotel, which I think is like in the new side of the Strip, $99 a month. So, which is going to be an amazing hotel price. So credit-con.com. I get nothing out of that. It's just the event that you want to be at if you're really wanting to hang out with people and have a good time and really learn. But yeah, it was exciting. We got to launch my brand new software, which does the Metro 2 type factual disputes. And it's interesting, John, because like I did a little 2-minute demo video for my website for people to see, and I was like went through the factual letter generation, and I said, hey, here's your factual letter, which is what I called it. And somebody asked me, like, well, is that still Metro 2, right? And I'm like, well, yeah, because you got to put the data in there, which is the facts, but then the reason why you're saying it's inaccurate is Metro 2. And I've had to explain that to a few people, and then I think it's kind of an interesting topic here for this show because, like, there's all sorts of different information about Metro 2 that are out there. And, the consumer really doesn't have the ability to, like, audit like the furnishers, like you have no mechanism under law to send anything but a dispute. Like if a furnisher doesn't certify the information to the bureau, which is what Metro 2 requires, I mean, you can't go in and like audit whether they certified it or not. But what you can do is you can take the definitions of the data fields that the Metro 2 gives you. So like it's a data format. So it's like your date open is this, your date closed is supposed to report this way. And if that data is inconsistent or inaccurate or doesn't conform to what their own regulations or the industry standard requires, what I share with people is you use that as really the reason for the inaccuracy. And so, like, what I kind of explain to people is, Metro 2 and factual disputing, like, a lot of people do factual disputing, but they can't give any sort of a basis as to why it's not factual, except for how they feel. They look at it and they're like, well, I just don't think it really looks right. You can't really take that to a judge. But if you do factual and you say, okay, well, these data fields can't be reporting all these different ways because you all have one industry standard, that's kind of how you tie Metro 2 to an actual factual dispute. And so, I've got stuff buzzing in over here. Look at that. So I thought that was just kind of interesting and noteworthy because there is a lot of information about Metro 2 that's out there and compliance and things like that. But if you want to tie it to your dispute, that way you can then take it to a guy like you, John. If you're like, hey, here's my dispute and it's factually wrong, And the basis for this factual wrong is because your Metro 2 manual itself clearly says it can't report this by. I think that's a pretty solid way to hand a case file off to you. Would you agree?
Yeah, it is. And, let's take a step back. In sort of any industry, there's the idea if you can sort of name something, then you set yourself apart. And so we see some of that in this world, right? We see people say, well, I'm a Metro 2 specialist, or I don't do actual disputes or factual disputes. I do Metro 2. Well, what does that mean? Okay, well, 5 people, it might mean 5 different things. But what we're talking about is we start at the base level is the Fair Credit Reporting Act. Information has to be complete and it has to be accurate. Well, how do we know if it's incomplete? How do we know if it's inaccurate? Now, sometimes we just know. Like, I paid off the Capital One credit card, and 6 months later they report a balance. That's wrong. I don't need Metro 2 to tell me that. That's just wrong. But then other times Metro 2 can be helpful because that's the industry standard, and it might say when X, Y, and Z happens, here's how you report it, and they don't report it that way. And so we can say, right, look, you're violating your own Metro 2 standards, and that can give us some leverage here to show. Remember, it's all about the base level of FCRA complete and accurate. Well, Metro 2 is just a tool to do that. And so there's nothing magical about it, but on the other hand, it is very powerful to understand. And like any tool, you can do great things with the tool, or you can cut your fingers off with the tool if you don't use it right. And I certainly see people out there that are, self-proclaimed experts on Metro 2, and it's sort of painful to watch. And so let me just finish. What I'd say to the people that are watching this is, if it's good to get mentors, and if you find somebody that you're interested in, just make sure that they do know what they're talking about. That they have been tested, and by that I don't mean some exam. What I mean is tested by real life. Whether that's you don't want a lawyer telling you what the law is who's never stood in front of a federal judge doing this type of case. Okay, there's a difference between book knowledge and, well, here's what judges have done over 20 years of experience. And somebody who's not a lawyer, like yourself, Stephen, does this person have real world experience? Or did you go to a seminar last weekend and you learned this thing called Metro 2 and now you're selling it? No, you've been doing this for many years. So that's the thing I would suggest people, you just want to make sure who you are sort of taking advice or guidance from knows what they're doing, and they're not just selling you something.
Yeah, and you can't really blame people for all the misinformation because the Consumer Data Industry Association, CDIA, which is the trade association of the bureaus, they're the ones who own Metro 2, essentially. They're the ones who own the data format and kind of control it and everything. They make it very difficult to get your hands on their manual. Fortunately, in 2009, I was actually able to go online and I purchased it and they mailed it to me, which is like, it was a miracle, because a lot of times they will actually refund money back because it says that they won't sell it to credit repair, but they sold it to me. So, I mean, that's their deal. But a lot of times,
they sell my money back, because I tried to buy it, I think in 2019, and I got this email saying you are ineligible to purchase our product. And it's like, okay.
Now, and you're an attorney. How in the world do they kick back on an attorney? Did you give them some flack on that, or did you kind of like acquiesce? How does that work when you try to tell an attorney you can't buy it?
So what I was going to do is just in our next case, demand it in discovery, and then they would say, oh, this is confidential, proprietary, and I'd say, well, I need to see it. And Judge, I tried to buy it. They wouldn't take my money, so they can give it to me for free now. And but then, we found it online. If you remember, what was that, back March of 2020? And
right.
We put it up in the training group. And so, I didn't need to sort of push that angle. But again, it's useful, okay? But, it's not magical. You still have to do the work. You have to read. You have to study it and really understand before you start throwing it out there in dispute letters.
Exactly. Yeah. And so it is available online, for those who may not have your hands on the Metro 2 manual. It's called the Credit Reporting Resource Guide. And if you dig around, there's a 2011 version and there's also a 2020 version that's available online also that you can dig around and get in. It is really important to have if you're going to be a credit repair professional, because that is the industry standard. And that chapter 4 of it has a list of all the data fields. And so when you get the credit file disclosures, the credit reports from the bureaus, they look similar, but they don't look identical. And that right there is the initial question that I had like 10, 11, 12 years ago, John, was like, when I first got my hands on this manual and I'm reading it, I'm like, why do these disclosures not list even all the same fields? And one example is TransUnion has a field on their paper reports, the paper disclosures that they give you, and the dispute results. They have a field that they call account type. But that field is actually the portfolio type. But yet Metro 2 actually has a field called account type. So you talk about confusing, and it's kind of like you just have to ask yourself, do these bureaus like just do this on purpose, or the real answer is they're just really practically too big to fail? They've got so much money that they just have these processes, and it's really such a technical thing. Honestly, I've gone up, I've had dozens of clients. We've sued the bureaus through the years, and I've been in depositions with the bureaus, and their attorneys, they're amazing attorneys, obviously, but they're going to practice law, and they're going to figure out what they're going to do, but they are by no means Metro 2 experts. I can tell you guys that right now, right? And so, don't get all arrogant and think, well, that means you're going to beat them all the time, because there's ways where they can just play the law game and whoop your ass, and of course just basically outspend you. But the point is you're not going to have the guy who programmed the paper template for the file disclosure at TransUnion. That dude ain't never going to be nowhere that has to do with litigation. You know what I mean? They've got, and then their corporate lawyers don't know what's going on as far as all that's such a big company, but it's law firms, it's third-party law firms that they hire for these things. And these, they've got lawyers at these firms that'll deal, with, say, TransUnion a lot, but they also deal with other things as well. And they're not Metro 2 experts, and they very rarely even get sued on Metro 2. And if they do, and if they have to produce it, to John's point, for discovery, it's not like there's somebody who really knows what's going on with that thing. And so it was really just kind of, it's kind of interesting when you figure this thing out. It's like, it is their industry standard. Why does all their stuff look different? If you look at a TransUnion paper report and a TransUnion annual credit report and a TransUnion direct portal report, the HTML on that thing shows you different, the screen shows you different things, and then on the annual credit report, and it shows you different things on the paper report. Like your Equifax paper reports don't even give you any positive payment history. Like literally, they only give you negative payment. It's the craziest thing in the world, So this is kind of the high level, like dumb it down, like how Metro 2 ties to factual disputing, right? You look at it and you find the errors, and then if you say, oh, well, Metro 2 says that it's supposed to have at least at a minimum a 2-year complete payment history, and then like literally you get an Equifax and there's no positive payments at all in the paper template, like just don't print them. Well, clearly it's factually wrong, and it's logical, but instead of saying, well, it just makes no sense, now you can say it makes no sense, and by the way, it violates your own industry standard, because your Metro 2 manual requires that you report at a minimum a 2-year complete payment history, right? So that's really how I think, an easy way of just saying how we can kind of combine the factual and the Metro 2 for disputing purposes, So,
yeah, the thing I was going to add to that, Stephen, is, and this was brought up at CreditCon the past couple of days, this sort of 24 months of, historical payment data or trended data. So instead of just saying, were you current, 30 days late, 60 days late, what were you? This would show, what was the account balance? What was the schedule payment, the actual payment, the high credit or the credit limit or high balance, the rating. And that's starting to be taken into account by the scoring models. They are starting to look at this and say, well, wait a minute, it's more than just were you current, were you late, what is your balance right now? We kind of want to see your balance over time. And so it makes sense from a scoring perspective, which is all about risk. If if we look at, your credit report, Steve, and it's got a $5,000 balance on a credit card, but it was 40,000 and that thing came down, well, that's a better position than mine that has a $5,000 balance, but it's been shooting up to 5,000. I'm heading in the wrong direction, you're heading in the right direction. But that just emphasizes why it's so important for us to see that trended data, the historical data, and to dispute when that's missing, when it's inconsistent, when it's just flat out wrong. So let's see, we've got a couple of questions here. Let's pop this up. So thank you for the live feed, and you're very welcome. So I did certified letter. That's very good. I'll say this, Steve. There were some comments made at CreditCon about, you don't really need to. Let me see if I can change this here. Certified mail is not really a big deal, and you're just sort of wasting your money. And I 100% disagree with that. And this, I think, we'll get to it here. So you did certified mail over 30 days. I assume you mean Equifax signed for it over 30 days. No response from Equifax. And they did not put dispute by consumer on your report, whatever accounts you disputed. So I suppose the question is, what can I do? What should I do? Well, first of all, if you had sent it regular mail, the answer would be nothing. There's nothing you can do because we have no way of knowing if it made it to Equifax. It may have gotten lost. And so it would be unfair to blame Equifax, to sue Equifax when we have no idea if they received it. But since they received it, now you've given them 30 days. It's possible that they could have mailed your results of investigation, and now that's slow getting back to you. But if you look at myequifax.com, there's a dispute section. It may show up there. You could call Equifax, say, hey, what are the results of my investigation? I know you got my dispute letter. And they'll say, no, we didn't. You say, yeah, you signed for it on this day. And they'll kind of, hem and haw a little bit. And then finally they might admit that they got it. I say, we're really short staffed with COVID. There's this thing called COVID out there. It's like, yeah, buddy, we've been dealing with this a year. Get yourself situated where you can handle disputes, or stop credit reporting. If you can't handle disputes, don't credit report. And so, what I would do is see if there are results of your investigation. The other thing you do is pull your new report. Okay, so you have the original report that caused the dispute, then you have your dispute. Now you should have the results of investigation, but you can at least get a brand new credit report, and do that every week through annualcreditreport.com. And if you did actual disputes that identified real errors, inaccuracies, incomplete information, and they didn't fix it, then sue them. I mean, that's a simple answer to it. And Steve, what do you say about that?
I think you need to give them your phone number. It sounds like you're ready to file a lawsuit against these people. So, I mean, it's always a balancing act when you're doing credit repair, whether you want to pay for certified mail or not. I mean, I don't think that the certified mail is going to get you any better results, but when they fail, that's when you can prove it, And so, yeah, I mean, and that really kind of, I think, depends on what kind of business model you're trying to have. I would build it into the cost of what you do. I mean, we send things priority mail, the priority flat rate envelopes, which come with a tracking number. And I mean, so I could see when it's been delivered over to them. I could put it certified if I need to. But I mean, and because of kind of how I do my disputes, where I do like generally one letter per account, and I, just kind of put all the data in there, it's not going to fit in like a little envelope. I usually need those little flat rate envelopes, and they come with a tracking number. So I think it's important definitely to be able to track your mail, and to be able to build that cost into your business model for sure.
Yeah, and Fern, I'm not sure if you are doing credit repair or you're a consumer, doing your own credit repair, but this thing on certified mail, and I mentioned this at CreditCon, that I want to say it's like the last 5 times I've sued Experian, they never responded to our dispute letters. I never got results of investigation. And so if I had sent those, my client had sent those by regular mail, we couldn't sue because we have no way of proving. So if if the model is, and you have to decide what your model is, if the model is, I'm going to send a letter that is completely sufficient, it has all the information, it identifies everything, and they'll either fix it or they'll delete it or we'll sue, then I would definitely do certified mail. Now, that's not everybody's model. Some models are, let me send multiple disputes. It may not be worth it to do certified mail. And so if you don't get a response, you might send another one. You might try to do it online, might try to do a fax. I don't know, does Equifax, ironically, does Equifax have a fax number, Stephen?
They do have a fax number, yeah. Equifax does have a fax that still works.
Okay, so that's good. I think TransUnion keeps like unplugging theirs, right? Or something like that.
Yeah, and I think the CFPB just turned theirs off too.
Yeah, so Matt Listro has like completely wiped out the CFPB and TransUnion. So thanks a lot, Matt. But you put on a great show.
Right.
Great show.
Yeah, the CFPB, I'm sitting here thinking, not only did their fax volume go up and get blown up, but every time they receive a fax dispute, they'll like mail you a letter, because I use a POA on mine. Like I get all these letters from the CFPB. You could do like one letter per trade line. I don't have like one letter with like 20 trade lines in there. Like every time I fax them disputes on a consumer, I get like 10 or 15 or 20 letters mailed from the CFPB. And it doesn't identify anything. It doesn't identify the consumer or the trade line. It's literally just some like, hey, we're the CFPB and we're putting you on notice that we received your stuff, you know? And I'm like, I can imagine why they unplugged their fax machine, because not only is it jamming up their machine, like they had to figure out how to print all this freaking correspondence that they weren't otherwise printing. And they wouldn't send that to you also if you use their portal. If you use the portal, they just like email back to you. So I think we jammed up their fax machine and their print machine.
I got you. Well, do it online, I suppose. Let's see. Wanda says, appreciate you both. Thanks for your efforts to bring this information to the public. Enjoyed it. Well, thank you very much, Wanda. It's very, very kind of you. And here we have the legendary student loan guy, Charles Bill Parker. Can a husband be added to a credit card judgment when the card solely belongs to the wife and the husband was never on the original contract? So I'll say this, in that situation, if the husband was not on the card, he should not be sued. If there's a judgment just against the wife, then you wouldn't add a husband to it after the judgment. Now, there may be something with community property or something like that I'm not sure of, but just in general, you should only be sued for things that you're on the contract. So if I make Stephen an authorized user on my Discover card and he runs it up, you know, because he's out with Matt Listro at all hours of the night.
Give me your Discover card. Of course I'm going to.
Yeah, that was a mistake, you know. And then I can't pay it, and they sue me. Well, they can only sue me. They can't sue Stephen. So he just like rides off into the sunset, you know, happy-go-lucky guy. And so
that sounds like a pretty good deal. You want to mail me my card now?
No, not at all. So, Charles, if you've got maybe some more information on that, you know, we'll be glad to try to answer that. Let's see here. So, Stephen, here's some follow-up from Fern. I called Equifax. They state they did not receive my dispute letter, but I disagree since I have documentation. Clearly states they received my dispute letter. Certified is vital. Yeah. Don't you love, Stephen, when these companies will lie about getting stuff and you're like, I'm looking at the green card or the online tracking from the USPS. You know, it's just amazing.
You could just be that they're misinformed. They may not be lying, John. I mean, we got to give these big corporate beasts the benefit of the doubt. You know what I mean? But yeah, I mean, so actually though, let's talk about that. You know, I know we like to beat them up, but there may very well be a logical thing going on here. Like because of the whole COVID stuff, especially you and I just came back from CreditCon and somebody talked about this. Like literally, so if it was sent certified green card mail, then yes, somebody at the post office from Equifax did sign off on that bad boy at the post office to you. So you're right, they received it. But somebody was doing a presentation, John. They were like, there's like literally big giant truckloads of mail just sitting at the bureaus, like that they can't even get into. So they may not have been lying to you. Like they may, because they don't have any record of the green card. You know, I mean, that goes back to you, their green card receipt. So it may very well be sitting in some big ass 18-wheeler out wherever their thing is, because with COVID, right, they haven't had the staff, and of course the CFPB just kind of gave them a slap on the wrist and said, don't worry about it. So, I mean, it may very well be like that they're not really like lying to you, that when they look in their computer, they don't see it. That's their problem and not your problem. Well, it's kind of your problem because your dispute isn't getting reinvestigated. But I mean, it's their problem, the fact that they've signed off for it and they're not conforming to the 30-day requirement. And so, John, I mean, how do you pitch that to a judge? I mean, at this point, because there is no, I mean, what you're suing them for is for failure to comply with the 30-day deadline at this point, because they didn't really fix anything, or they didn't even conduct a reinvestigation. So it's like, we can't say you didn't do a reasonable reinvestigation, but you literally just, like, it's the deadline that they didn't comply to, right? I mean,
yeah. So this is something like maybe 10 years ago we first ran into, where this was Experian. And so it used to be with the other credit bureaus, you didn't need to put like your driver's license, a utility bill. They would accept everything, but Experian would reject it. So, we figure this out. So our client sends a letter, driver's license, utility bill. Experian sends back a letter, says, we received something suspicious, purportedly from you, but you need to give us your driver's license and a utility bill. And so we just had our client handwrite on the top of the letter, like, second and final notice, kind of like a debt collection letter. And it had the original letter with the, driver's license, utility bill. Well, they sent another one back saying, we can't process this because you didn't do your utility bill and driver's license. So we sued them, and their response was, well, we didn't do a lousy investigation. We did no investigation. So we're scot-free. We have no liability. And so we kind of encourage them to present that argument to the judge, to just say, hey, Experian's found the ultimate loophole. Just don't investigate and you can't get sued. And, they quickly back down off of that. So our position is, you had 30 days to do a reasonable investigation. I really don't care what you did if you did not do a reasonable investigation, and no investigation is certainly not a reasonable investigation. And
now, before you take a case like this, though, you're going to want to make sure that the basis of the dispute letter, like, there was some sort of,
right.
It was like, let's talk about that. I mean, even though the FCRA, like the language of the FCRA, you can send them whatever, and if they can't verify it, they're supposed to delete it, right? I mean, like, that's the language of the FCRA, but 50 years of case law later, you basically have to have damages. That's what the judges kind of want to see, even though the FCRA itself doesn't require that. And you're going to want to be able to show the judge that, like, there was actually something in the dispute letter other than prove it or remove it, right? So, I mean, if she sent the letter, I'm just saying, Fern, not that you sent this, but if her certified letter basically said prove it or remove it, that's a legitimate dispute under the FCRA. It really is, right? Because if they can't prove it, if they can't verify it or record the current status and update it, they're supposed to delete it. But let's say her letter just said prove it or remove it, and she's got a certified thing. And let's say she's got some damages, okay? Maybe she's been turned down for credit, and so she was like, I don't recall this thing, prove it or remove it. Would you litigate on that, given the rest of her fact pattern, or would you want this to be more of a solid, like, hey, by the way, your balance is reporting it consistently or whatever? Like, where's your minimum floor threshold on things like this when they just don't hit the 30-day deadline?
So it's really the same whether they investigate or don't investigate, whether they send results, don't send results. We've got to show that letter to the judge. And the letter has to be something that the judge is reading that going, okay, yeah, I see these look like errors here. Okay, Equifax, what did you do? Well, nothing, Your Honor. Well, then you're kind of up the creek. Now, if it was a sort of these things you find, prove it or remove it, or, unless you give me a wedding signature, even though I've used this credit card, to buy $27,000 worth of stuff, I disclaim any responsibility for it. That's just junk. Like, no judge doesn't care if Equifax writes you back and says, we refuse to investigate. It doesn't matter. Like that, there's nothing there. So we have to have actual errors. So again, an error is it's inaccurate or it's incomplete. Now, sometimes those two things merge together, but they're not the same. Everything on there could be accurate, but there's missing data. Well, that's incomplete. Or there could be, every data field is supplied with information. It just happens to be wrong. Okay. So now usually what we find is there are inaccuracies and incompleteness. And so if we have a solid dispute letter, that's really the key. And that's why, I've said it here, I said at CreditCon, you need sort of the before, the during, and the after. The before is what your credit reports look like that prompted the dispute. The during is what'd your dispute letter say? And then the after is the results of investigation and new credit reports. And so, we need to have those good, solid disputes. And I'll tell you, Steve, it's sort of like Experian is notorious for rejecting dispute letters and saying, we deem this to be suspicious. Well, what's your basis for that? Well, the people that process the mail, if they just get a gut feeling, they throw it in the suspicious bin. Well, too bad. But we have to have a valid dispute. If we do, then they get hammered because guess what? They gave up their right to do a reinvestigation on that.
You must have not seen the instinct provision of the FCRA when you were in law school, John. They can go off of instinct, gut feeling. Yes, they do have the right to do that. Just throw it in the garbage can if they feel as though it's suspicious.
That's right. A buddy of mine in Birmingham, great lawyer, Whit Seals. He popped Experian for millions of dollars, and sadly, the 11th Circuit took away the punitive damage part, but he exposed a lot of what they do with this sort of suspicious letter, just nonsense. Okay. And one thing I want to say, and then we'll get back to the questions, is because this was mentioned at CreditCon, and I don't know if the speaker just misspoke or if the speaker was just misinformed, but there was this idea that back when COVID hit and we have the CARES Act and we have the CFPB, that somehow they blessed the credit bureaus to take longer than the statutory time period, which is 30 days to investigate. And they said, it doesn't matter. You can go beyond that. No worries. You won't get sued. And that's just absolutely false. What the CFPB said when this came out is we, the CFPB, won't take any regulatory action against you if you're making an honest effort, if you take longer than 30 days. Well, guess what? I didn't say that to the bureaus, okay? I didn't give them a pass, all right? My fellow lawyers that sue credit bureau, we didn't give them a pass. Congress didn't give them a pass. The CARES Act doesn't say anything about this. And so I was a little surprised to hear this sort of myth continue to be said that, oh, well, they had immunity up until April of 2021. No, there's no immunity. And they had the opportunity to investigate. And one of the speakers was talking about all the outsourcing, and it's staggering. Close to 90% for most of the bureaus is outsourced to, countries that don't speak English. And
so that's not dispute outsourcing, but the bureau's processing of your disputes.
Right.
The bureau outsource their label. Yeah, it was Guatemala and India, I think, were the two countries, right?
Yeah, and Colombia, for Experian. And so, that's a business decision. That's fine. Okay, that's great that they did it. But then they go, oh, well, COVID's hit and we can't reach our contractors there. And hey, you got my letter? You're still reporting on me? Do the investigation. It's sort of like back in the Great Recession when the big banks said, well, we want to do all this risky stuff. And if it's successful, we reap all the rewards. But if it fails, then we want the handout and you guys, make sure and take care of us. And, heads I win, tails you lose type of thing. Let's see here. We'll go back. Let's see. Wanda, what's the difference between a regular FICO score and a PayPal type score? Stephen, I'll be honest, I have no idea. What's a PayPal type score?
I am not sure, Wanda, either. Do you want to kind of clarify? Was PayPal, maybe that's a typo from like an autocorrect. You mean like a VantageScore? I guess what we could say is so I'll try to answer your question, but I don't know what you mean by PayPal. But So obviously the credit score is not part of your credit file. The data is what makes up your credit file. And then the scores, there's different algorithms based on the type of risk. So there is no one FICO score. You've got like FICO for credit cards, FICO for auto, FICO for mortgages, because there's a different type of risk associated with each of those purchase. So there are actually multiple different FICO score models, is what they call those, basically different types of algorithms. So you can go today and apply for credit at 3 different places, have the same credit report, but if you're applying for a credit card and an auto, if they apply a different scoring model, then you're going to have a different score. Now that's FICO. Then you've got like VantageScore, which really the lenders don't use. And so it's another score that they've created to be able to give a score to a consumer and not have a FICO. But hopefully that helps you. If you want to clarify on that, we're happy to retouch on that in a little bit.
Yeah, just
down here, Vantage is what she meant. Yeah, okay, cool.
Oh, okay.
So you meant Vantage. Okay, cool. So hopefully, good question. I know that auto text correct thing will get you every time, huh? So, PayPal score, huh?
Yeah. So Vantage is by the bureaus, right, Steve?
Right. The Vantage is owned by the bureaus. That's correct.
Yeah. It just hasn't caught on. I want to say, was it 90% of lending decisions that are scored are FICO dominated? And we talked about this at CreditCon. There's, for example, FICO 10, which changes some things. And then there's FICO 10 with the letter T, and that's for trended data. Well, that's a little bit different. And so, even within a FICO credit card score, there's different versions of that. And so even if, like you said, same credit report, you might get different scores. So it can be frustrating because we think just how sort of common the FICO score is. It's like, well, what's your FICO score? Well, it depends. There's like 20 models here.
Right.
So,
right.
So
they call those the FICO scores.
Yeah. So Wanda, here's what I would say to you. If you get the Vantage score, maybe you get that through some product you have. It's useful, but use it for kind of directional. Are you going up? Are you going down? Because it typically will track the FICO score, but the numbers may be different. Okay. So I think I've used this illustration before. If you're trying to lose weight, you have a scale, the scale might be 5 pounds off, but directionally it should be correct. Is your weight going up or is it going down? That's, the number itself might be a little bit off, but you're looking for the directional move. And let's see here. We got our buddy Charles, will do. And then let's see, here's something else from Charles. Given that the credit bureaus are falling behind, not doing their part processing letters, it seems like, which, yeah, absolutely. Would you recommend to put that into client contract to cover yourself as a credit repair company, basically putting wording in your contract of the expectation? So that is a fabulous question. And Stephen, what are your thoughts on that?
Well, I think if your contract is kind of well written to start with, where you just kind of say that you're not really responsible for what the bureaus do, and you set their expectations, right? You could have anything in your contract, and if you don't set their expectations, then you're done. So I really think more so than putting something in your contract is to set their expectations, right? And then so, if somebody's paying you month to month and they haven't got any results in 3 months, you're probably going to have to make a business decision. Do you want to give them a free month, or what do you want to do there? You can have it in the contract that's like, hey, I'm going to charge you every month, but they're going to just not do their thing. And if they get pissed at you and do a chargeback or file a complaint, then you've got a whole issue. So, I think it is good to have language in there that, you're a third party helping them and you're dealing with these big giant companies, and it's really up to the companies how they react. But I think this is really more of just you figure out how are you going to kind of pivot and set expectations, and then handle when those expectations, when the client doesn't get too happy with it. What are your thoughts on that, John?
Yeah, I think that's good. And Charles, one thing you could do is, you could record a video, put it on YouTube as like an unlisted video, and just when you have clients, or maybe send it out in an email blast kind of to everybody, like, hey guys, watch this video. It's a very important message. Or you could use, Loom or Zoom, or whatever the method is to record the video, and just have a 2 or 3 minute video to your clients saying, look, here's the issue we're all dealing with. People all over the country are facing the same thing. These credit bureaus are not responding timely, and we can't control that. What we can control is doing the absolute best disputes. And, and from the standpoint of you, the client, make sure you give me those results back that you do get. And Charles, one thing we tell people, for some reason I don't have my phone around here, but imagine holding my phone up, is, Android, iPhone, is we tell all of our clients, download Adobe Scan. So, Adobe, like Adobe Acrobat, Adobe Reader. Adobe Scan, it's a free scanning app. It's, to me, better than the paid apps that are scanning apps. And so some of those, you scan one page and you have to send that as a PDF. Well, you can scan multiple pages and then send it. And so we just tell all of our clients, because I would get these pictures of like, it's sort of crooked in a dark closet and you can barely read it, Well, this is sort of like doing a mobile deposit. It'll kind of fuss at you if you don't like get it right. But it's a fabulous scanning app. And so, maybe it's a time, Charles, to really emphasize to clients like, look, I'm going to do my part. We can't control the bureaus. You make sure and do your part. Give me the results back. And, if you've done solid disputes and they're not fixing it and your client's willing, then, sit down and talk with a lawyer about that. Let's see here. All right. Facebook user.
So I'm not sure. Robert Galvin.
Robert, okay.
Yeah.
So Robert says, can a third-party debt collector report each charge within the total balance that the original creditor is charging the consumer as separate collections on the consumer's credit report? So let me give an example. I think what you're talking about, Robert. So I owe $1,000 to some creditor, and they send it to a debt collector, and they break it into 10 $100 accounts. And what are your thoughts about that, Stephen?
So I think probably where you would most commonly see that, I'm assuming, would be in medical. And I am not a medical expert, but we've got, Michelle Peoples. She's in our big pre-litigation Facebook group, John, and she's a medical billing expert, and she does credit repair as well. And she did a presentation once, and she kind of said that, like, with their industry standard they've got for medical billing, they've got standardized codes, and they're supposed to bundle things. Like, if I go there, and again, I am not at all speaking if this is actually the deal, but just kind of for illustrative purposes, if I go in there and like I get an IV and a drip and a shot of something like to numb my pain, those things are kind of supposed to go together. So they're supposed to be bundled, which means like they're kind of like billed together, as opposed to like I get one bill for the shot and another one for the IV and another one for the needle. So again, a very elementary example, but my understanding is that based on the medical coding standards for that industry, certain things are supposed to be bundled. So I guess that being said, from if it's a medical bill, you would want to go in and see if they're billing according to, I guess, their own standards. And Michelle Elwood Peoples, you can check her at Facebook, or feel free to message me. I can connect you up if you need a question on that. I don't really think that this situation would apply unless, Robert, if you want to give me a situation more specific, but I can't imagine this applying for something other than medical. What are your thoughts, John?
Yeah, and Robert said it was medical collection.
Cool. Okay.
So
yeah. So
there is a bad Seventh Circuit, which Seventh Circuit is Indiana, Illinois, maybe Wisconsin. I'm not sure. Where a collector put like 10 different accounts on the credit report, and the consumer sued and said you should have bundled those as one. And my memory is, this is maybe a year or two ago, the Court of Appeals for Seventh Circuit said that's okay to do it because those were separate bills. But I think Stephen's point is your starting place, which is, like when the consumer got the letter, the bill from the hospital, was it like, here's invoice number 1234, here's the due date and it's $1,000, and then some debt collector broke that into 10? Or did the consumer get 10 different bills? And then that last case, I think the collector's probably okay. But if it came as one bill and then the collector broke it, I would certainly, raise a little bit of fuss about that and probably go back to the hospital or the doctor group or whoever it is, say, what's going on, guys? And again, get with Michelle, because I'm certainly no medical billing expert. I'm confused when, you go to the ER and like 3 years later you get a bill from a doctor you never heard of, and you're like, I didn't even see that doctor. And so,
okay, so he's saying it was one bill. So Robert, do you mean like it was originally sent? It was originally sent as one bill, and then the debt collector split it. Is that kind of what you're saying? If you want to give us clarification, in that case, I would say that's definitely uncool. That's just probably some litigation waiting to happen if they split it from one bill.
Yeah, because and Stephen, if I'm misstating this, let me know. But I think I'm accurate with this. For most scoring models, and some it will ignore medical within certain parameters, but $100 collection account is basically as devastating as $1,000 collection account. And so if you have 10 collection accounts, I mean, that's not accidental by the collector. They know exactly what they're doing. They are, driving your score down to inflict maximum pain on you. And
that's why I like talking to attorneys, because you guys like have no obligation or duty to like withhold personal opinions about these people, because you'll never be like an expert witness. You can basically just, describe them as trying to optimize the pain. So he said correct. Okay, so it sounds like you got yourself a winner on your hands there, Robert. If they split this bad boy up, so I guess what can he do? He can send in a dispute. So he can send in the dispute to the debt collector, and validation of debt, or some sort of something like that, and ask them to validate or verify the reporting and validate the debt. And if they send you one bill, then it's like, why is this reporting as 10 trade lines? The other thing that you could do is just try to communicate directly with the original medical facility. If you can get them to recall the account from the debt collector, that will have the immediate effect of the trade lines being deleted when a debt collector gives the file back up to the original owner. So maybe you could use something like this as leverage, with the original facility. Like, hey, I appreciate you guys are trying to collect the debt, but there's something nefarious going on with your debt collector. Like, they literally split this thing up into 10 trade lines. Can I assume that they're purposely trying to destroy my credit to pay you? And I'm sure, Mr. Medical Hospital, you have no intention of, this happening. And so let's just you and I deal before I have to send them, all these letters and you guys get rolled into it. So you may be able to use that to your advantage and have a conversation. That's where using HIPAA actually can help you. This is certainly not going to be a HIPAA violation. That's a big misunderstanding. But you can send a HIPAA letter requesting, to speak to their HIPAA person and disputing it under HIPAA. And they're supposed to send you like statements of the people to whom they've shared it. But the point is, none of that's really factually relevant. But the point is that you can use HIPAA to send a letter to the hospital. And they've got a HIPAA person that is trained solely to keep them from getting sued under HIPAA, because that's what doctors don't want. They don't want to get sued under HIPAA because they've got their insurance and their malpractice. So if you're having trouble getting in front of the right people at the hospital, what I'm saying is you could use a HIPAA letter. And I know you're in our training course. We've got a whole module on all the different HIPAA letters. And just pick one, legitimate ways to communicate with them. It's not going to be like a credit dispute, but it gets you in front of the HIPAA person, and they're going to communicate back to you and be like, hey, I'm the HIPAA person. And you'll be like, great, well, here's what I want to talk to you about. Thanks for reaching out. So that is one way to get a real person. And they're trained from compliance, right? Again, they're not really credit reporting people, but they're trained for HIPAA compliance. So like their little spidey sense radar is going to be like, okay, I mean, how can I, within reason, keep us from getting sued? I'm not saying it's going to work guaranteed that they'll recall the account, but if you want to try to do it, and if you can't get a hold of them just talking, a HIPAA letter is another way to be able to actually get somebody at the hospital on the phone with you. If you, assuming you've got a POA for your client. If you don't have a POA, this could be a value add upsell opportunity for your client. If not, have your client call them.
Yeah, and it was mentioned at CreditCon, if you take a big bank and say, here's the chief marketing officer, here's the chief risk officer, they have different motivations. And it's the same thing, the person in charge of accounts receivable at the hospital, they may be like, great, I'm glad I got your attention, co-collectors. But somebody over in compliance may be like, whoa, this just doesn't feel right. Are we doing this to more than one person? Are we doing this to thousands of people? What's this collector doing? So it may cause enough anxiety with the hospital that they say, you know what, let's just grab that account back. Now, if you do go to the collector, I would make it very clear in the letter, look, I'm talking about all these accounts. I think you've got 10 accounts on me. Why are you doing that? Explain this to me. It came as one bill, to help me understand what's going on. And then that causes some anxiety for them because they're like, well, do we collapse them into one? It's not legally an admission that what they did was wrong, but it certainly doesn't look good for them. Or do they double down and say, oh, we're doing it this way? Well, you gave them a chance and now they get hammered. So I think that you've got a lot of options there, Robert, on which way to go, and keep us posted on that.
Who's going to be doing the hammering, John? That's all. Is it going to be John Watts? John Watts, the medical hammer?
Hey, you always want to be the hammer and not the nail, right? Be the windshield, not the bug.
Nice.
Christine says, I've disputed the errors, asking the bureaus to prove it and or remove. I never heard back from either one of them. Disputed since July 2020, heard nothing at all. Well, Christine, that goes back to what we were talking about. You got to make sure that your letters contain the actual errors in there. So an inaccuracy or something incomplete, preferably both. And if I'm not saying your letters are this way, but if your letters are just saying, hey, here's a list of 10 negative accounts, so like, I don't remember these accounts, please prove these, and you really do remember them, you had them, then there's really nothing that can
I got it. I think I hit my head. I've got this all of a sudden said, I cannot recall.
If you truly don't know what the accounts are, then you say that, because it could be identity theft. Somebody stole your identity. It could be a mixed file where two files get mixed or merged together. So there are times where we say, look, I don't know what these accounts are. But like Stephen was saying earlier, and you may have typed this before we got to that part, when we just say like, prove it or remove it, well, that may work sometimes as credit repair, but that has nothing to do with putting them in sort of the pre-litigation position, which is they fix it, they delete it, they get sued. And that's,
let's talk about that just kind of real quick here. I mean, like the whole prove it or remove it concept, you can do the same concept, but if you put some factual data in that letter, then it changes the entire dynamics of the letter. So instead of just saying prove it or remove it, which I get it because nobody's credit repair software allows you to do meaningful factual disputes until now with Palmieri system, right, John? But my point is
that might have been a commercial message.
Was that? That was a commercial. Yes, go to palmierisystemdemo.com and check out my 2-minute video on the amazing software we launched for factual letters. But my point is, if you take prove it or remove it, but then you're like, and here's what I mean specifically, Mr. Bureau, prove that the balance is reporting these different ways. Here's how the balance is. The date open is reporting 2 different date opens. This payment history from 3 months ago is reporting current on this one and 30 on this one, right? Please prove that they're all correct or remove it, right? So like my point here is kind of like, the whole concept, if you just take a little more effort and you put that factual data in there, they can't prove that the conflicts, the inconsistencies are accurate, right? So take a little bit of time, find out what's wrong, and then just kind of put a little more effort, reword it, and say, I'm just confused. I don't know how you could possibly prove that this is all accurate. Which one of these is correct? If not, please remove it, right? And that would be like a totally legit, not to say that yours isn't legit, but that would be a totally legit letter where you could hand that thing off to John, and he's got it nice and buttoned up to where, he can submit that thing over to a judge, and a judge will be like, oh, well, this is something that even I can understand.
Yeah, and here's a way to think about it. Just always imagine your letter, a judge reading it. Can that judge read just your letter with nothing else and say, yeah, if that was on my credit report, I'd be a little ticked off too. Now, if it just says Capital One, prove it or remove it, judge is going to be like, what is this? But if you start laying out the details, here's what's wrong, here's what's missing. I want you to, the letters that we do say, I want you to fix it or delete the whole account or fix each and every error. And my view is, if I find 27 errors on one account, guess how many errors I'm listing in my letter?
27.
It's 27. Like, why would I hold any back? Like, I want to put it all out there, and then they either fix it or they delete it. And hey, we're happy either way. And if
they don't fix it and they don't delete it, in which case you've got leverage now.
Yeah. And option 3 is they say, please sue us. We're begging to give you money, and then delete the account. Well,
when John says that, like, that's actually the letter that he gets from the bureau. Like, the bureaus respond back with a 30-day notice, and they're like, dear John, please sue us. We're begging to give you our money. That's actually what those dispute responses say. Isn't that right, John?
That's right. I like to think I'm a nice guy. Why would I turn down somebody who's, asking to help by paying money to my clients? So, but in all seriousness, I mean, just do those letters very specific. Rachel in our group, one of the lawyers from New York, talked about this yesterday, or my days are mixed up, Stephen. I think that was yesterday, about being very, very specific. Don't just say the payment history is wrong. Say, here's why the payment history is wrong. Here's why it's incomplete. Just spell it out. And, don't worry about how long your letter is. It should be as long as it needs to be to communicate what you're trying to communicate. Let's see here. I think I lost track of where we are. All right, let's see here. Okay, so let's see. Out in California, reach out. Yeah, reach out to me. There's some guys in California that I work with, and so very happy to help you. And then Christine says, why haven't the bureaus responded? Well, it could be that it was not certified. And while they would deny what I'm saying, this is my opinion, is that they get a regular letter, regular mail, and they're like, we're so behind and we're so backed up on processing. Look at the letter, toss it. There's no way to prove they got it. Now, if it's certified and they do that, it's just being done. That's why they do it. And here's the other thing, is they know for every 100 people they do this to, maybe one will go to a lawyer. And then there's probably 150 of us in the country that do this. And there's, 500,000 lawyers or something. So even if you get to a lawyer, the odds are that lawyer's not going to know what to do. So it's a very, very low risk thing for them. They don't have to pay to investigate a dispute, and they can just move on, which, see, when you make them investigate a dispute, you're costing the bureaus money. The bureaus are in the business of making money. When people buy a credit report, they pay money. When people credit report to the bureaus, as crazy as it sounds, they pay the credit bureaus to do that. So the credit bureaus are in a great place where money is just flowing to them. You dispute it, now they got to start spending money. They are not happy about that. That is not their business model. So that may be why they're not investigating it.
It's just your little hunch.
Yeah, that's my hallucination. So let's see. I just opened my mail to find a hospital where my husband died a few months ago is billing me. I never signed for anything. Can they do this? Elderly with SSDI as my income. Well, first of all, sorry for your loss there. It could depend on what state you're in. if you're in, I don't know if community property state has anything to do with it. There are some states where, I forgot what it's called, the rule of necessities or something like that, where sometimes family members can be obligated to pay, but most states say, I have no legal responsibility for my adult children. They have no legal responsibility for me. And now if I sign or if they sign, that's something different. But, Wanda, just reach out to me and let me know where you are. And I think I know where you are, Wanda, but just reach out. Let me make sure I've got the right Wanda in my mind. And, maybe use that Adobe scan and send me a copy of that bill, and I'll be glad to look at it. And said, thanks for the scoring detail. You're very welcome. And let's see here. So we have Easy33. Thanks for all your content. Great work. Much appreciated. Well, Stephen and I appreciate the chance to come to you guys. So
we study hard to prepare for these shows for you too, like feverishly.
So let's see. Let's see here. So exactly what I was thinking.
That was Robert with the medical.
Robert. Okay, great. All right. If the collector is collecting on judgment, trying to collect $800 more than the judgment, what questions do we ask to find out why they're charging higher than the judgment? So a couple things. It could be court costs. So they may have gotten a judgment against me for $5,000 plus court costs. That might be $800. Probably not, but maybe part of it. And then there's post-judgment interest. So imagine this. All right, so back in time here, I default, and then they sue me and they get a judgment. Well, that judgment should contain all the interest going back. But then going forward in time is what's called post-judgment or after judgment interest. So that could account for it depending on, was this 3 days ago or was this 3 years or 13 years ago? And each state has a different interest rate for post-judgment interest. But look, it's a legitimate question to ask the debt collector or the collection law firm. Say, hey, I understand I had a judgment for $5,000. Why are you guys collecting $5,800? Help me understand that. And let's see, you are very welcome there. And let's see here. We have, what can you do if you miss the court date, have a judgment? Can you renegotiate the judgment? So depending on your state, you may have time to ask the court to basically overlook this. In other words, maybe you thought the court date was at 9 o'clock, is really at 1 o'clock, or vice versa, or you thought it was on Monday and it was on Tuesday. And the judge may say, okay, I'll give you another chance. If they don't, you may have the right to appeal, and you always have the right to talk to the other side about settling a judgment. It's not fun. Obviously, they have a judgment that puts them in a strong position, but you have the money, and they may be interested in getting the money without having to chase you through garnishment and things like that. Any thoughts on that, Stephen?
Do you have people with that, or is it just not really financially viable for them to have somebody like you try to negotiate settlements, judgments?
I'll say this: if somebody has a lump sum, so let's say the judgment's $10,000 and you have $6,000 that you can get your hands on, it may make sense to go to a consumer protection lawyer in your state. If you're calling the other side to work out $150 a month payment, I don't know that a lawyer really does much for you. I've been hired in both of those, but I always tell people that, want the monthly payment. I'm like, really, you don't need to pay me for that.
Right.
I can bring some value to it, but honestly, it's probably not worth, what you're paying me. But on a lump sum, I think it's definitely worth having, a good consumer protection lawyer that can go in there and say, hey, we can find some reasons to fight this, but we also have some money available. And, you just have to calculate what's the attorney fee, what's the savings and that type of thing. Let's see, I popped this up, and this is your PalmieriSystemDemo.com. See if I can show my screen here.
Yeah, so we've got a 2-minute demo video on there that kind of walks you through really just a high level of the software. It'll pull in the credit reports, your credit monitoring, and it's designed for CROs, not really consumers. So if you're a consumer, feel free to reach out to me or a CRO. But brand new in the marketplace, it'll generate those factual Metro 2 letters with the errors right there populated on your dispute letter for you. And you can put the errors from all 3 bureaus on one letter, which is really powerful if you're doing furniture disputes, because you can put the furnisher on notice of everything that's wrong from all 3 bureaus. So PalmieriSystemDemo.com. Take a look at it and look forward to anybody's feedback there. Appreciate you pulling it up there. You're a pretty good screen roller there, John.
Well, it's right now I've only got my laptop. I don't have a second monitor, so normally I'd pull that up on. But for me to see what's happening, then it's like looking in a mirror. But
yeah, because I noticed you're not in your usual office. Is that because you're coming to us from a different location?
Yeah, from a remote location. So I've got the white background. So I may be in prison. You never know. They just happen to give me a laptop here, so nothing stands in the way of legalese show.
That's right, exactly.
So let's see here. Eric says, what's the easiest way to dismiss a lawsuit for an account that's already been settled? So I guess I would have a couple questions for you, Eric. Did you get sued and then you settled it? Well, once you pay, it should be dismissed with prejudice. Or did you settle it and then you got sued? So if you settled it after being sued, then that should just be a conversation with the collection lawyer. Say, hey, look, I paid this. I followed all the terms. Now dismiss this case. But if you settled it and then you got sued, then you need to talk to a consumer protection lawyer who does the FDCPA, Fair Debt Collection Practices Act, because if you settled it and you made the payments, you owe nothing, and then you got sued, that's bad for whoever sued you. So that would be the distinction I would make is, did the suit come first and then you settled it, or did you settle it and then you got sued? Those are 2 different worlds there. And let's see, are all debt defense attorneys looking for countersuit opportunities when defending a client? So it's a great question. There are some debt defense lawyers that is their kind of standard procedure. Let me find a counterclaim, let me bring a counterclaim, leverage that counterclaim into maybe reducing the amount we have to pay, or maybe we pay nothing. It's not my model. I'll just tell you that. When we find the violations, we prefer to bring those violations in a separate lawsuit. So we try to keep them separate most of the time. There are exceptions, but we want to defend the lawsuit and then sue the bad guys. And we tend to not combine those, and there are some reasons for that, but it's just a different approach there. And let's see, Wanda says North Carolina. Yeah, reach out to me, Wanda. I think I know somebody in North Carolina that could help you there. And then Eric says, can't the contents of a certified letter be challenged? Is it that valuable to send a certified letter? Well, to me, the answer is yes. Okay, so I'll give you the example that is often given. I've heard it at CreditCon is, well, people sent certified mail letters that were empty. Okay, first of all, I don't know who does that. That's weird. Okay, there are weird people in the world, and I assume the speaker is has a good memory of that they got some blank certified mail letters. But in 25 years, 26 years of practicing law, filing lawsuits, certified mail is sort of the gold standard. Judges understand it. And they'll even say sometimes, did you send that certified mail? Yes, Your Honor. Here's the UPS or USPS tracking. And they're like, I got it. They understand certified mail. So, one way is if you use a mailing service. So certifiedmaillabels.com is one. Stephen, what's some other, is it Streamletter or LetterStream or something like that?
Yeah, they'll do your processing. But I guess my question is, if you don't type the certified number on the letter, then I think that maybe goes to Eric's point, is how do you prove that the letter being produced is the letter that was actually in there if there's nothing on the letter next to the recipient that says sent via certified mail and here's the number?
Yeah, so you can manually type that. Again, if you use these services, usually there's a function where you can click a little button and it'll print sort of like a footer on the bottom of the page or a header on the top that's got the certified mail number. The other thing is, and this may seem like overkill, but we've had clients do this. They're like, pull out your phone, turn on the video camera. Hey, this is John Watts. Today is June the 10th, 2021. I printed these letters, and you show the letter. I'm sticking this in the certified mail, and now if Equifax is going to say, yeah, we see that video, but we think you got to the post office, you ripped it open, you pulled it out of the letter, you resealed it, you sent it, a judge is like, and what else? The tooth fairy? It's a very weak argument by the bureaus. Okay, incredibly weak. So, now let me say this: if you send a letter and your only copy is a Word document on your computer, yeah, you got problems that the bureaus are saying we never got it. I mean, you need to, when you print this out, if you're sending 3 letters, physically print out 4 copies. One goes to Equifax, Experian, TransUnion, and one goes in your file. And that way you can say, I print this out at the same time. Scan it in, put it on Google Drive, Dropbox, Evernote, whatever. You want to have this in the cloud, physically on your hard drive. And then again, it starts to strain the credibility of these bureaus when they go, well, we think even though you have all that, you didn't really send it to us. Let's see. Okay, so
that's Timothy Williams posted that up on Facebook.
Okay.
Yeah.
So Tim from Montgomery, Alabama, is a resource guide, the mystery reinvestigation process. So how would you respond to that, Stephen?
Tim, can you give me some clarification, please? So, I mean, what he's referring to is the credit reporting resource guide, the CRRG, which is the Metro 2 manual, which has basically, it does spell out, there's a chapter in there on eOscar, which is kind of the automated dispute mechanism when the bureaus receive the information and they transfer it electronically via eOscar. So there is some reinvestigation information in there, but in general, the resource guide is basically it outlines their data format, the Metro 2 data format. How do you report accurate data? So the bulk of the manual really doesn't have anything to do with reinvestigations, but it has to do with how the data should be reporting. And I see you just posted up a clarification. Okay, you said should it be? So should the resource guide kind of be the I guess the gold standard for reinvestigation? So, I mean, that is the manual for their industry standard format. The industry standard format and Metro 2 is designed to conform to all applicable credit reporting federal and state laws, which includes reinvestigation. There is a section on eOscar, which is specifically for reinvestigation. So, I mean, I would say that manual is essentially the starting point of your gold standard, if that's what you're looking for. I would agree, yeah.
Yeah, and just real quick, because we sometimes throw out these terms, CDIA is the company, the organization that puts out this resource guide. We call it Metro 2. It's not the technical name, but that's the formatting system. It might be like saying, I don't know if this is not a good example, but I have a, iOS phone. Well, I have an iPhone. iOS is the operating system. But we talk about eOscar, just think of, here's a credit bureau, and they get a dispute. Well, they have to transmit that dispute somehow to the furnisher, the one that provides the information. Well, the highway that they use is called eOscar, and they send what's called an ACDV. So it goes to the furnisher. Furnisher's supposed to investigate, and then they send it back through eOscar to the bureau, and then the bureau notifies you. And so The resource guide, the Metro 2 guide, does talk about that some, but that's not the focus. As Stephen said, the focus is really on how do you report the data accurately in the first place. And so hopefully that helps. Let's see, Chris said, thank you for sharing your time and knowledge. Well, you're very welcome.
You're welcome. Yeah.
So Rodney says, what if you had a car repossessed, but you never received the intent to sell, and then you found out it was sent to the wrong ad? Okay, that's a great question, Rodney. So generally, I'll say not always, but almost always, car repos are going to be covered by your state version of the UCC, Uniform Commercial Code. And in almost every state, there's a requirement that they send you this intent to sell. Basically, a letter says, hey, we have your car. We intend to sell it, within 14 days or after 21 days or whatever they say. Now, if they don't send you that, and then they don't send you the follow-up letter, which is after the sell. So here's the repo. They send you the intent to sell. Then they sell it. And then they have the, hey, we sold your car. And here's the math showing you how much you still owe. If they don't send you one or both of those, some states say they can't recover anything. So it's just what's called a bar to a deficiency. Other states say, well, maybe it will prevent them, or maybe you can reduce it. You may have to prove that it made a difference. So it really depends on what state you're in as to how strong your position is on that. Anything to add to that, Mr. Stevens?
No, you got it all. I'm good.
All right, Virginia, sued by a debt collector. Case was dismissed with prejudice. Reporting on credit as meets FCRA requirement. Can I have it deleted? Okay, Virginia, I absolutely love these cases. We have lots of these cases. We've been doing these since like 2006, okay? And so here's the deal. Dismissed with prejudice, unless you have a very unusual state, that's the same thing as winning your case. And so what we always recommend, and you're welcome to reach out to me directly at alabamaconsumer.com and send me your paperwork. Let me see your credit reports. And we can help you dispute that. And basically the dispute says this: hey, Equifax, Experian, TransUnion, there's a Midland funding, there's a portfolio recovery, there's a Capital One, whatever it is. And that's on my credit report. These guys sued me. Here's a copy of the lawsuit. That's going to have the court. That's going to have the case number. And I won. Here's a copy of the order dismissing with prejudice. Now, they'll always say, well, we think you forged those documents. So we put in the letter, if you think I'm making this up, call the court. You got their number. You can look it up. Call the collection lawyer. It's on the complaint, the lawsuit. Now, the guys, the folks that do the investigations have no access to the internet. They have no access to make a telephone call. And when we depose them, put them under oath, we say, do your people even have a pencil and a piece of paper to write on? They're like, nope. I mean, all they have is a terminal, but they can't like go out and Google something, okay? So, but you put all that in there because, again, a federal judge is going to be reading this letter going, let's see, she told you that she got sued, she won, and she gave you the lawsuit and the order, and you still verified that. Why in the world would you do that? Okay, so to answer your question, Virginia, you can get it removed. Typically, they will because they've been sued so many times. At one time, we had, I want to say, we were like on our 50-something lawsuit against Midland Funding, Midland Credit Management. I mean, we've sued these guys so many times. They know this is the deal, not just in Alabama, but they know in other places. So they typically will get rid of this. But, I mean, right now I can't even tell you, 4 or 5 pending lawsuits against all the bureaus or almost all the bureaus in every case. And the furnisher, the debt collector, the original creditor, because they didn't remove it. So it puts you this way, it'll get deleted or you'll have a fabulous lawsuit and they'll be begging you to delete it and to pay money. Okay, so get with me or do it yourself. but just you want to make sure, in my view, you want to make sure here's the lawsuit, here's the order, get this off my credit report. Make sure you can match it up. That lawsuit fits with this account on my credit report, and definitely good luck with that. Let's see here. So Stephen, we have David saying, I have a charge off that was sold to a third-party debt collector, which is now on my credit report. The third-party debt collector sold it to another collection agency. So let me give you the scenario, Stephen. I have a Capital One account. They sell it to Portfolio Recovery, who's on my credit report, and then Portfolio sells it to Midland. Who can be on my credit report? Midland, Portfolio, or both?
Well, your original creditor, and then, well, boy, you've got a lot of options there. Your original creditor can report up until a point where they sold it. And then typically whoever bought it, the debt buyer, is going to report it, not their collector. Typically buyers who have collectors, those collectors don't report it.
Right. But they can. So here's the
they
point.
Can. That's why I said that's a tough one.
Only one collector can. So on my Capital One debt, $5,000 I defaulted on, it goes to Portfolio Recovery. Well, they can report it. But if they then sell it to Midland, well, Midland can report it, but Portfolio can't. They better get off my credit report. If Portfolio, and they don't do this, but if Portfolio said, well, we're going to send this out to a collector who will then report on your credit report, well, I can't have two collectors reporting the same debt. So if, Dave, if I'm understanding your question, the third-party debt collector bought it and then they sold it, well, that sort of middle company, the first debt buyer, should not be on your credit report because there's nothing for them to credit report. They don't own the debt anymore. Yeah,
and are we certain, David, that they sold it to another debt buyer, or do they still own it and they have a third-party debt collector collecting on behalf? Because like Resurgent Capital and LVNV, they've got that cozy little relationship. They own it and they've got all their own little affiliate subsidiary companies that'll collect. So, but yeah, you should only have one debt collector report the trade line.
And that collector should be the one that either owns it or is actively collecting on it. Let's see, David has a follow-up here. Do I have to send another debt validation letter to a new collection agency? Short answer is yes. When it goes from one collector to another, you do have to notify that new collector your, refuse to pay or dispute letter doesn't normally travel to a second collector. You've got to go individually to them. So let's see here. Oh, somebody's asked a terrible question.
It's Warren Maxwell. We can just bypass his permission.
Warren, abort this thought. There's too much student loan in this.
Warren, you just keep on doing credit repair and utilizing folks that already have the law degree. Don't you become a consumer lawyer.
Yeah, so the best way to become a consumer lawyer is to become a lawyer and there's either nothing else you can do or that you want to do. So
basically just refuse to sell your soul to the corporate giants.
There you go.
And then live in average cars, driving Hyundais, and then you could be a consumer lawyer. Now, if you want to drive like Bentleys and have yachts, you can go work for Experian or TransUnion or Equifax.
There you go. So let's see. Okay, Virginia's given us a little bit more information. Dismissed without prejudice. Yeah. So without prejudice basically means it's like the lawsuit was never brought. Okay. With this one exception. So you can't get it off your credit report just because it was dismissed without prejudice. But I will say this, if you were sued and you answered and disputed the debt, then even if they dismiss it without prejudice, they still have to, if they update your credit report, they have to mark it as disputed. So sometimes you can catch them violating the law that way, where, give you some dates. They sue you on January 1st, February 1st, you file an answer disputing the debt, and then you pull your credit report April 1st, May 1st, June 1st, and they're updating your report but not marking it as disputed. Then you could sue Doesn't mean they have to come off your credit report. It just means you can sue them under the FDCPA if this is a debt collector, the Fair Debt Collection Practices Act. So yeah, huge distinction between with prejudice and without prejudice. With prejudice, you won. Without prejudice, it's like, well, let's call off the game, and it never happened. Okay.
It's like dismissing a bankruptcy, basically.
Yeah, except, they can still sort of linger on your credit report.
Well, but I mean, it's kind of like it's like as if it never really. It's like you're just going back to where you were. You can always file again. You can always go do the lawsuit again.
That's right. That's right. So let's see. Who is this?
That's Robert McAvoy. He found our pre-litigation big Facebook group today and messaged me. We had a phone call actually, and he'll be joining the training course tonight. Yeah, super excited as well, Robert, to have you check it out and stuff. If you like this, imagine when you pay us $99 a month, how excited you'll be for that time.
There are better backgrounds. We have good-looking, models and actors that do all the speaking. You won't get us.
You think this is amazing? Just wait.
So let's see, David. Does it matter because the original debt falls off my credit in 6 months? Well, it kind of depends on, from a standpoint of getting it off your credit report. You might not care because it's only 6 months. But then again, if Stephen came to me and said, "Hey, John, I'm going to break your finger every day for 6 months," 6 months can be a long time. Okay. And so I don't want him to do it much less 6 months.
Well, in that case, I think I would be perfectly qualified to work for the CIA. I could be one of those CIA torture guys if I'm going to come.
Yeah,
break your finger every day for 6 months.
Yeah, for 6 months. So, but now in terms of if it's off your credit report, but they may still have time to sue. So that's the statute of limitations, the time period to sue. And even if they're beyond the time to credit report and the time to sue, they still can collect. They have to be very careful collecting, but you may still want to get that debt validation into them, or you may want to even send them what's called a refuse to pay letter that says, "Hey guys, I refuse to pay any debt that you have on me. I dispute these debts. I refuse to pay." And then if they contact you again, it almost certainly violates the FDCPA. So just to let you know, next Thursday at 11 Central Time, I'll be doing a webinar really all about dispute letters. So what's the difference between a dispute letter, a validation letter, a refuse to pay, a cease communication? When do we use these? When do we combine them? When can we not combine them? What's the effect of that? So just get with me, and I'll put a thing up on YouTube about it as well. But just go to alabamaconsumer.com. You can just put your name in and the contact form, say, "Hey, notify me about the webinar," and I'll get all that. I was supposed to have all that ready, and got delayed at CreditCon, and so that didn't happen. Excuses. There you go. Right.
Blame CreditCon.
It's all Matt Listro's fault.
That's right.
Let's see. Okay, here's a very, very interesting question, Stephen. Small medical debt from 5 years ago, adding $1 every month. Is that re-aging? So what would you say to that? And then we'll answer the other question, which is this right for them to add $1 every month?
Yeah, I mean, I guess it all depends upon what you mean by re-aging. Typically, I guess there's two ways people look at re-aging. One is the date that the 7-year clock is calculated from for purging it. That is the date of first delinquency. So this would not be re-aging in that effect. Other people call re-aging like the date of last activity. I don't believe this would be re-aging in that effect. So I don't think this would have anything to do with re-aging. It sounds like just that the balance is going up. And so then the question, to John's point, is it legal? Do they have the lawful right to raise it based on interest or whatever? But I don't think it's any sort of re-aging.
Yeah, so like Stephen said, re-aging is that 7-year period. Well, it doesn't matter what they do with the balance, how many times they sell a debt, et cetera. That doesn't change the time period it comes off your credit report. But you would want to know, under your state law, do they have the right to add $1 to it every month? I'll tell you this, normally medical debt, they, at least in my experience, they don't do it. Now, what's her name? Michelle Peoples, is that right?
Right.
Yeah, she may say, well, yeah, we do this all over the country, or this is never done. But that would be my question, because if they have no legal right to do that, and presumably this is the debt collector doing it, then you've got a good lawsuit against them. And you sue them and they go, well, it's only $1. Well, Stephen, I'm only breaking your pinky finger. I mean, look, you got like 270 other bones. Like, what's the big deal? One little pinky finger I break. He's like, well, I kind of like my pinky finger. I like my dollars, Don't put false information, even if it's $1. And, if they've been doing this for a couple of years, it adds up, And so, the funny thing is, like, let's say your Discover card, your minimum payment's $39. What if you pay them $38, Stephen? What do they hit you with?
30-day late payment.
Yeah, you didn't pay it. It was only $1. Well, It works the other way too. So, so definitely check out your state law on that. Let's see. Wish you had an office in Texas. Well, I do have some friends that work in Texas, and we do some work together. So, let me know.
I have an office in Texas. Come by. If you're in the Dallas area, shoot me a message. Let's do lunch or something.
Yeah. So here's an interesting question, and I have some thoughts about it, and I'll let you go first, Stephen. What do you think of legal shield types of service? This would be where you pay, I don't know, $50 a month, and then you sort of have a lawyer on call. Maybe you can get a free will, get discounted legal services. What do you think about those? And let's answer it from two perspectives. One from the consumer standpoint, and then like a business such as a credit repair place that might be selling these legal shield type of services. What do you think about those two perspectives?
Yeah, I mean, from a business perspective, it could be a good ancillary type service that you can sell to your clients, and it's a service that they could potentially use. I mean, I'm not personally a legal shield affiliate associate. I mean, I prefer to just have like real lawyers like you, John, that I can refer my clients to. But for a lot of folks, that's not, you don't have that network built up, right? So then the question is, okay, I mean, are you selling it because it's just some sort of a smart way to build a residual income? Okay, that's one thing. Are you selling it because you think after your disputes, your clients can use legal shield to sue the debt collector? That probably isn't really going to happen. But I mean, I do think from a business perspective, if you can work it in, it's a great way to be able to remonetize your clients and build a residual income. I do think that makes a whole lot of sense. But I also think that there's no replacement for having contacts like John and a lot of other consumer protection attorneys who we know.
Yeah, and I'll tell you my experience with them. There's a firm, and this is a few years ago, so it may have changed, but there was a pretty good sized law firm in Montgomery, Alabama. And they sort of serviced all the people in Alabama that had, I don't know if it was Legal Shield. There's several versions of this. And, you would call down there and say, hey, I just got arrested, or I'm selling my house. Can somebody look at my contract? Or, I'm going through a divorce. And this is sort of a full service firm. And I think that people got pretty good service. It may be excellent service for the basic things. You want just a simple will, a power of attorney. It's great. Maybe you got a traffic ticket or something. I think it's great. I wouldn't go to them if you're merging together, two $10 million companies, right? You shouldn't be worried about, well, I can get a 25% off hourly rate. You're going through a complicated divorce. I'm not sure that's where I would go. And, you have a personal injury case. Don't go there. You want to go to somebody that this is what they do. And I think same thing with consumer protection, but it certainly can be good. I mean, you might pay $500 a year and you get a will. Well, you might pay somebody $500 to do a will. So from the consumer standpoint, I think it has value. Okay. Just don't think of it as this is literally going to solve all your legal problems. From a business owner, as long as you think you're providing value to your clients, and I would just make sure they understand you're getting an affiliate, a referral, whatever you want to call it, then it can be a good business choice. Let's see. Virginia said, apologize for the error, but statute of limitations has also expired. Got to still sue them. So let's just sort of cover these real quick. So statute of limitations is the time period to sue you. Okay, that's expired. Then there's the credit reporting time period, or the obsolescence period. That's at 7 years, basically from the date of first delinquency. And then there's just the time to collect, okay, which is unlimited, but with huge restrictions. So as far as you being able to sue them, you would want to find a violation. So did they violate the Fair Debt Collection Practices Act, the Fair Credit Reporting Act? And then keep in mind that under certain state laws, if you sue them, even though their claim has expired, they may be able to counterclaim against you. So it's important to sit down with the consumer protection lawyer and say, hey, here's my situation. And I was telling the folks at CreditCon, which basically are credit repair companies, if you're going to a lawyer, and this be true of a consumer, here's the before, the during, the after. Here's what happened, here's what I did, here's where we are now. Now tell me what can I do, or what do I need to do next? And I think you'll get some good answers. Let's see, somebody can't wait to watch the replay. So that's good. We're glad that we are replay worthy, hopefully. And let's see. Okay, David gave us a little bit more. This is about the creditor sold it to a debt collector, then there's another debt collector. So it sounds like the first debt collector still owns it, and then they have a collection agency. So that might be like LVNV claims to own it, and they have like capital management system. They have all these incestuous relationships with these little firms. I'm sorry, they have relationships with them. Maybe I shouldn't say incest, but anyway, I've sued them a lot. So anyway, you still have to send a new letter to that collection agency, and if let's say it's LVNV and they're reporting, but they have somebody else like capital management collecting, LVNV could still report as long as they still own it. You just couldn't have two collectors reporting at the same time. So hopefully that makes sense. And let's see. Hey guys, great seeing you this week.
That was Subhan Tariq.
Oh yeah. So that's one of our lawyers from New York. Very smart guy in New York. And if you have any questions about Bitcoin, this guy is all over cryptocurrency.
He's your crypto and consumer protection guru. Yes, Subhan Tariq.
So funny thing is, he'll tell defendants like, hey, why don't you pay the settlement in Bitcoin? And I don't think they take him up on it, but he's a real cool guy. Let's see. Can debt collector, Midland, or portfolio pull inquiries on my report? They like to do soft inquiries every few months. Seems like they don't have permissible purpose. So let me say one thing, and then I'll have Stephen address this. So it is true we have this distinction between soft pulls and hard pulls. The FCRA makes no distinction. That doesn't exist in the Fair Credit Reporting Act. People go, well, soft pulls, they don't hurt your score, so they're legal, and hard pulls has nothing to do with Fair Credit Reporting Act. All that Fair Credit Reporting Act says is to the bureaus, you better make sure somebody pulling a report, again, no distinction between soft and hard, they have a permissible purpose. And that tells a user, the person that's going to the credit bureau to get your report, hey, you better have a permissible purpose. And if you lie about it, that's actually a crime if you lie about it. Plus you get sued for it. So there is a mechanism to have a permissible purpose for collection purposes. So that's what they're operating under. Now, if let's say that Midland sued you and they lost, and they continue to pull your report for that account, not for another account, but for the account they lost on, they have no permissible purpose. Portfolio says you owe $1,000, you settle with them, you pay them $800, and then they pull your credit report for that account, no permissible purpose. You bankrupt, wipe out Midland and portfolio. Again, for the accounts wiped out, they pull your credit report, no permissible purpose. But just in general, they do, as long as it is an account that they either own or they're looking at buying, and it's not already been settled or discharged in bankruptcy. But you can always write them a letter and say, hey guys, I saw you pull my report. tell me why you had permission to do that. What are your thoughts on that, Mr. Stephen?
I got nothing more. You covered it all. You
Yeah,
took
so
the exact 5 paragraphs, 10 paragraphs right out of my mouth with that whole diatribe there.
Yeah, well, I heard you say that one time, and I memorized it and stole it, so that's why it sounds.
That's right. That's right. You've got a good memory.
Let's see. Let me go back because Brian is asking about that. Okay.
Brian's got a picture with Gary Vaynerchuk, man. See, I know who Gary V is. That was a cool picture there, man.
We'll go back. We want to look at that again. So
those old guys like John, they don't know who Gary V is, but us young guys, we do. Cool picture.
Yeah. So this re-aging and adding $1. So that's what we were talking about here. So Brian, who's there with some famous people at issues. So yeah, we talked about that. Basically said it's not re-aging, but check your state law to see, do they have the right to add, maybe it's interest or something, to medical debt every month? That's a little unusual, at least in my experience. And let's see, David says, is reporting a charge-off on your credit report month after month after the original charge-off legal? So Stephen, I'll let you take that one.
That's actually accurate reporting. And because, think of it like your payment history. Your payment history reports the payment as of each month. All the other data fields, like your balance, that's kind of where that trended data that FICO is using now. They get that data because it's all reported every month. And so what it's saying is that as of that particular month, the current status of it is in charge-off status. So it actually is supposed to be reporting that way every month. That's actually how their industry standard requires it to be reporting. So I know it's not what you're looking at here, but that is accurate reporting.
Now, I will tell you one thing to look at. You might have I don't care who it is, Bank of America. They're reporting on you charge-off, started being charge-off January 2020. You paid it off in November. Sometimes you'll see December 2020, it'll say a charge-off. To me, that is incorrect because you paid it off in November. There shouldn't be anything negative in December. And now there may be some convoluted reason they have for doing that, but I'm just looking at from a simple way. If I paid it off in November, I don't owe you any money in December. If I don't owe you any money in December, I can't be 30 days late, 60, 90, 120, 150, 180, or a charge-off. So that's something to look at. Sometimes I don't know why, but they'll put that sort of follow-up month. So we dispute that. They don't get rid of it, then we encourage them other ways to get rid of it. So let's see, Jay Martinez, Dallas. I think that's for you there.
I'm in Dallas, Fort Worth. So find me on Facebook. Shoot me a message. Let's do it. Let's connect.
Yeah, so Stephen will gladly meet with you at any of the finest steakhouses, as long as you're paying for it.
Heart 8 Barbecue. You pick your Heart 8 Barbecue location, best barbecue in Texas, in my opinion. You buy, I'll meet you there. That's a fair deal.
Let's see. I'll come by Dallas. I can check out the suite office for the Palmieri system. So who is that?
That is Warren Maxwell. Warren, I'm going to hold you to that. You need to come to this fabulous office that we have. Yes, sir.
All right, very good.
You in the Palmieri system also. Don't be talking about things that you have no business talking about now, Warren. We need to get signed up for the software, man.
So let's see. Chris says, can debt collectors resubmit old accounts in a manner in which it impacts your credit score as a new debt? So to resubmit, let's say they had a $100 collection account. Can they submit that so it looks like a new debt? I'll say this. I've occasionally seen people dispute, XYZ debt collector. It gets removed, and then 2 months later, it comes back under a different name with slightly tweaked account number. And we sue them for that because I think that is false to do that. How about from a Metro 2 standpoint, Stephen?
Well, so, if it is like previously reported and then it transfers, so I guess was it, first of all, they've got a problem. If it was if it's being resubmitted, why was it deleted to start with? Why was it removed? So was it removed because they willingly, without a dispute, they willingly decided to just delete it and cease reporting? Okay, that's one thing. Like maybe they made an internal decision. They looked at it one day and said, oh, this thing looks odd. We can't verify this thing. We're going to actually take it off of the report. And then maybe they verified it, put it back on. That's like one scenario. But that usually never happens. So was it disputed and then deleted because they couldn't verify it? So if they couldn't verify it and then they resubmit it later, they're basically certifying that they've been able to verify it. They have to do that when they reinsert it. But then now they're kind of de facto admitting that they didn't conduct a reasonable reinvestigation when they originally deleted it, because if they had the information to fix it, but they didn't fix it within the 30 days, they can't take like a year to fix it and then be like, oh, we're getting around to it. Now we're going to make it accurate and re-report it. So my question is, why was it like, how was it removed and then resubmitted? Now, to your point of the score, what I would say is that if it still has a balance, then if they're going to report it accurately, it is supposed to be updated every single month as collection status. I know we don't like to hear that. We like those accounts that have like not been updated in a long time, but they are actually supposed to be updating it every single month. So if they do that, yes, that's going to have a negative impact on your score. So, I mean, I guess on the face of it, I don't really see any problem per se with like it affecting the score if it's accurately reporting and they're updating it every single month as the current status of this reporting period is a collection. But I'm curious as to what was removed and then basically reinserted if it was the same debt collector. Now, if you're saying that like debt collector A deleted it and they transferred it to debt collector B, then debt collector B reported it, that's a little bit of a different situation because that's two different debt collectors, which they could definitely do. But that's kind of what I've got to say on that, Chris. Hopefully that helps you.
Yeah, and Chris, if it's the same collector and they report it for a few months and they take it away, then they report it again, and that seems to be affecting your score, you can always bring that to the attention of the bureaus and say, hey, somebody's playing games here. And, I will say this about the bureaus. They don't want furnishers doing stuff to sort of game the system and, to sort of artificially lower your score, because they're on the hook for that. If something comes off, like if you dispute it, it comes off and then it comes back on, that credit bureau has 5 days to notify you by letter, hey, this is coming back on. If they don't do that, they violate the law. And so they've got some liability. And there's also things called quality scores where they're sort of evaluating each furniture. How are you doing compared to your industry? And because they're looking for people that are not reliable. And so we would just need a little bit more information on that. And let me see, Stephen here. So are we coming up on 2 hours?
We are coming up on 2 hours. Yes, sir.
Okay. We'll start to wrap this thing up.
We're going to have to sell these people a second ticket. It's kind of like movie hopping. If you want to, you're going to have to go to the cinema next door. Your ticket here is almost expired, guys.
That's right. So I disputed something with the debt collector on my credit report. They removed it 2 weeks later. Well, very good. Since then, I've been contacted by 2 separate companies trying to collect on behalf of them. So, Brian, I would look at who these companies are. Do they claim to own it now or to be collecting on behalf of that original collector? And if they're both trying to collect on the same debt, and company A is saying you need to pay us and company B is saying you need to pay us, well, that's a situation where you may be able to say, well, one of them at least, maybe both, but at least one of them is lying because they don't have the right to do this. I mean, if you get 2 letters like the same date, the same debt, and they both say that you owe them, and these are 2 separate companies, well, again, at least one person's lying. And when we find debt collectors lying, there's a very simple solution. We sue them because they're not allowed to lie. And that's unfair and it's harassing. And so I would just say, kind of put it on paper, like exactly what the details are, the dates, make sure the account numbers match up and all that sort of stuff. See, Chris says, why are debt collectors able to sue on accounts past the statute of limitation under the pretense of breach of contract or account stated. Please explain. Okay, so let's take Alabama, for example. A credit card normally is considered an open account, which has nothing to do with your credit report saying account type open or closed. This is a legal designation. It's called an open account. And that's 3 years. Well, breach of contract is 6 years. Account stated is 6 years. So a lot of times, if it's beyond 3 years, they'll sue and say, well, we're doing this under breach of contract or account stated. Well, they do that to get around statute of limitation. Now, the question is, can they prove those legal theories? Very hard for them to prove account stated. And frankly, it's hard for debt collectors to prove a breach of contract because they have to show all the monthly statements, and they really struggle doing that. And account stated just doesn't work. The theory behind account stated is 100 years ago, Stephen runs a general store. I come in every 3 months and buy products from him, and he just keeps a little ledger on me. Well, that's an open account. But one day he's like, yeah, that Watts guy's not paying me. And so he writes me a letter and he says, hey, John, here's all the charges you made, all the payments, if any. Here's the account amount that you owe me now. Well, he has balanced the account. He has rendered the account. He's given it to me. And now that becomes account stated. And that's 6 years. These debt collectors say, well, every time Chase or Citibank or Bank of America sent you a credit card statement, that's an account stated. Well, under most laws, that means it's like a new contract has been formed. Well, trust me, those credit card companies would be shocked to know that they had formed a new contract with you every month, because that brings up Truth in Lending Act, all sorts of stuff. So they'll never claim that. This is the debt buyers saying, well, Citibank back there, they did this account stated. Well, Citibank would be shocked to hear that, okay? So they really struggle to prove those two things. And the good debt buyers, I'll say the better debt buyers, recognize this. And so, for example, in my state, Alabama, they'll send people letters that say, the law limits how long we can sue you. This is too late to sue you, so we won't sue you. The ones that are more willing to push the envelope and don't care if they go over the line will sue after 3 years. Let's see here. We have reading various comments on debt collection statute of limitations. Seems some judges consider credit card contract as opposed to open accounts. Some reason for it. Yeah, it really just depends on, can they prove a contract, which is, was there an offer? Was there acceptance? Do we have the terms of the contract? And then do we have a breach of the contract? Well, if the debt buyer can't prove what the terms of the contract were, so interest rate, late fee, over the limit fee, how does the interest rate go up and down? Well, then they can't prove the terms of it. Now, they might could prove just like ignoring all interest, all late fees, but then they would need all the statements to be able to separate all that out. So I think for most judges, as long as it's properly argued, they don't buy the idea of a account stated or a breach of contract. Let's see here. Stephen, here's one. I am of life, says I'm being sued, submitted paperwork via email. That is what my court said I should do, that I shouldn't come to court. Email bounced back 3 days after due. Now they have a judgment against me. So I would try to, as quickly as possible, get to the court, explain your situation. Probably need to explain that in writing. Just lay this out. If, who told you you should submit it by email? Was that by email, or was that somebody over the phone? Do you have their name? Do you have your email that you submitted it to? Did you type in the email address correctly? Was that what was given to you? So you just want to explain that as quickly as possible to the judge, because your time is slipping away. So you need to know how long you have to do this, and basically go do it immediately. And, it may be that we typed in the email address wrong. I certainly have done that. And, that's a mistake. And can you tell the court, look, I just made this mistake. Please cut me some slack here, or what the situation is. But definitely, it's a tough situation. And let's see, here's some more information. They said I need to file a motion, probably not win. So a motion is just a written request. So a motion to continue is a request to get more time. A motion for default judgment is a request for a default judgment. This would be a motion to set aside, to reconsider, to vacate the judgment. And
is the court allowed to tell her, like, you can do this, but you probably won't win? That sounds like they're like, that's something the judge should decide. Is that some sort of a legal thing? She can squeeze them one right there.
It's in poor taste, I'll say it that way. They said I could have brought the paperwork into court. However, I was going by website and recording on the phone for the court. I didn't know about. So what I would do is try to get that recording on the phone, call back, see if it's still there. If it's a recorded message, they obviously intend for it to be recorded. So record it. And then, when you file something, you could transcribe it and say, I have the file. You could put like a CD or a thumb drive with it and say, this is what I relied on. And I think that will help. Look, you're always in a bad situation when there's a judgment, but that may help here. So here's an interesting question, Stephen, if you want to take this one. If you do a settlement with the creditors, do they have to update the credit report to paying as agreed? If not, why not?
If they're a data furnisher, so if they've previously ceased reporting, as long as they're reporting, it's supposed to be every single month. At some point, they could just make a decision, we're going to stop reporting this thing. And so then it'll show you, let's say June of last year was the last month that it was reported, and it'll show you that it was through June of last year. So it's complete through that point in time. They're not really obligated to continue to report unless if you dispute it. So this will say June of last year, they stopped reporting, and here you are of June this year. So we're missing a year of history. And we're not talking about a debt collector that like reports and waits 2 months and reports again and waits 3 months and reports again. That is a violation of the industry standard. But they reported consistently and just ceased reporting, they could do that. And then if you settled, they still ceased reporting, that's okay. But then if you dispute it, they are supposed to update it with the most recent year of missing payments, which would then reflect that it was paid as a group, settled or paid or something like that. If you dispute it and it's not updated, then that's a problem, because they are supposed to record the current status of it, which means during the reinvestigation, the furnisher who made a business decision to cease reporting, in order for them to conduct a reasonable investigation, has to help the Bureau record the current status of it. That's a Bureau obligation. So it's not necessarily a problem if they just decide to cease reporting, as long as it's accurate through the time that it ceased. But if you dispute it and they don't completely fill in all the missing months and update it as proper, that would be an issue. So John, what are your thoughts on that?
Yeah, so I like to think in terms of examples. So let's say that Capital One $1,000, and they say pay $700 and we'll settle it. So, I was late, and then I reached this settlement. Well, they don't have to go back in time and say I was never late or I was paying as agreed. But from the moment I settled, anything from then going forward, it should show that it was settled. Now, I might say, was a charge-off, now settled in full or settled for less than full balance. So historically, they don't have to go back and sort of change history. But once you settle, that point going forward, they need to report it. So let's take Stephen's example. I was late, and then they stopped reporting for a year, and now I've paid it. Well, if they're still showing a balance of $1,000, that's false. And under 1681I, I can dispute anything on my credit report that's false. Well, guess what? The balance is false. So I dispute that. I don't owe them any money. Well, they better change it to a zero balance, or they violated the FCRA. So hopefully that's helpful. Let's see here. So should you make a counterclaim when submitting an answer? That's a matter of sort of preference, assuming you have a violation by, let's say, the debt collector. Some people like to do counterclaim. I personally don't. my strategy has always been, if I have a real claim, I want to bring that in a separate court. I don't want to get it sort of bogged down with the collection case. I want to beat the collection case and then have my lawsuit. I don't want the judge kind of like splitting the baby here, if you know what I mean. They owe you this, you owe them that. I like to keep those separate, for the most part. Let's see. Chris says disputed. Okay, this is the one where I think they kept resubmitting it. Disputed and removed and resubmitted years later. Yeah, I would say
resubmitted by the same furnisher. I'd say that's an issue.
Yeah, and it can be an issue for the bureaus, because they have to send you that letter within 5 business days, Stephen, 5 business days of reinsertion. Now, they'll sometimes argue, well, this is not a reinsertion. It's I forgot what the word is. They say it just got back on there again. And because we got tricked by the debt collector, they like added a few dollars and changed the account number. Well, maybe not. But then we're going to go hammer the debt collector. So the point is, somebody is probably at fault if this was deleted and then put back on, and you did not get something in the mail telling you by Equifax, Experian, TransUnion, hey, we're putting this back on.
Somebody screwed up, huh?
Yeah. So Gary V. So very, very good eye there, Palmieri. Isn't he in Dallas? I
don't know where he is actually.
No. I'm thinking of Cuban. Cuban's in Dallas.
Yeah, Mark Cuban's in Dallas. Yeah.
So let's see, if debt collection company A is reporting, they pass it on to B, and B calls without my consent, and this would be on a cell phone, auto dial call, or pre-recorded message. Would that be enough for a Telephone Consumer Protection Act violation? So generally, if you gave permission, say, to the original creditor, then they can pass that permission to company A, and then if company A passes it to B, that permission flows with it. The other thing is, for auto dial calls, we had a really bad decision. It was a unanimous U.S. Supreme Court decision on what is an auto dialer. It's called the Facebook case, and came out April, and really sort of gutted a lot of TCPA cases. Now, if it's a pre-recorded message, we don't care about auto dialer. So the question is, did you give permission to either collection company A or the original creditor, and did not revoke that permission? But assuming you gave permission, it wasn't revoked, then that can be passed on all the way through. So you need to revoke permission to potentially have a TCPA case. Let's see, Muriel says, good evening. Good evening to you. And let's see, Brian says, they claim to be collecting on behalf of debt collector A, not the original creditor. So yeah, it just sort of think of like, this is permission. Okay, so if you gave permission to the original creditor and then they hand it to a debt collector, the permission goes with it. And then if they hand it to somebody else, the permission goes with that until it's been revoked. And let's see, Jared says, I have a question about debt set off. So, Jared, if you'll just let us know what that is. What's your question? Great job, guys. Well, Stephen does a great job, and I try not to just complete.
Somebody's got to help you look good.
Yeah, that's right. So, okay, this is back to the emailing the court. I did not type the email wrong, have the error email. My email company had an issue with the court email address. Maybe it was a US or .co. So, here's the bad news, okay? It's sort of like you send let's say your answer's due on Friday, and you mail it to them, and the mailman loses the letter. Well, it didn't get filed with the court. Unfortunately, that's considered your fault. I know somebody that they were trying to save their house, and they had to make like a $5,000 payment by a certain date. They sent it by certified mail, did everything right. It's supposed to go to Wells Fargo in Iowa, and it ends up taking like a 2-month trip to Alaska. Well, we didn't pay it within the time period, and he lost his house. So you have to make sure it gets there. And I'm not saying that in an unkind way. I'm just saying, if you mail it, if you fax it, if you overnight it, you have to make sure it gets there. And, what I would try to argue to the judge is, you guys told me I couldn't come to the court, so I did it this way, and I didn't know it didn't make its way to you. And so cut me some slack here. And let's see, it looks like we have a follow-up. My concern is they won't care. I'll bring all the details, screenshot, print it out, go back, see if there's any way to capture their phone message. I would just try to call the phone message unless it's changed. And, they may recognize that was their phone message. So I would just try to say, if this is true, I wanted to bring it in person, but you told me not to. And then there's some technical glitch with, sort of like an email, sort of like a handshake, right? It's like there can be problems in that handshake. So I would just try to get them to help you out there. Hopefully they will. All right, so under 1692, and that's the FDCPA, since I request a verification of a debt, should debt collection cease until it's verified? If I was contacted by 2 other debt collectors for it, would that be a violation? So here's 2 scenarios. One, you request verification within the 30 days after first being contacted, then yes, all debt collection should cease. But if they wrote you what's called the 1692G letter 6 months ago, and now you are disputing it, you're sending requests for verification, they do not have to stop. And even within that 30-day time period, they only have to stop until they verify the debt. Now,
what if they just close the account, hot potato it, whack-a-mole to another debt collector?
That's totally fine. That's completely fine for them to do that. So
it seems like that's probably what happened here, huh?
Yeah, in that 30-day time period, if you request validation, verification, whatever you want to call it, they have 3 options. Number 1 is they can verify or validate the debt, and then they can start collecting. Number 2, they can do nothing. They don't have to verify or validate your debt, but they just can't collect. Number 3, they can send it to another debt collector, and that's what Stephen's talking about, the whack-a-mole. So you can get in this process where you're kind of chasing the collectors. And as soon as you send a validation, they send it to somebody else. Usually we see that with like cell phone bills, cable companies. Usually the best way to handle that is to go back against the original creditor, the cable company, the cell phone provider. Usually there's an arbitration provision, which can actually work to our advantage in this. And Brian, if you want to get with me, just reach out through my law firm, or if you go to my YouTube page, I think it's got my email address on there, and be happy to chat with you. So we'll try to wrap this up here. Stephen, let's see, when it comes to paid or settling derogatory accounts with creditors, would they have to update account status and payment status to close paid and current status, or do they just update accounts settle for less? So what do you say about that, Stephen? What does Metro 2 require, if you know off the top of your head?
Right, you wouldn't have both of those. So it would be one of those statuses. So if it was derogatory account, then it would be a final status of basically paid and closed. And your payment history is often kind of like misunderstood, but your payment history is always trails behind 1 month of your whatever your current reporting is. So you can still show that it was, collection last, your most recent payment history for last month would be collection. And then the account status for this month would show, was collection, now paid. So it kind of bridges the gap between the payment history for last month and then the fact that there was actually 2 statuses in the current reporting period. Was collection, now paid, or now paid and closed. So so it wouldn't be current. It would be, the was payment, was collection, was charged off, now paid, is how that would report.
Yeah, the only thing I'll add to that is, and we don't see this with credit card, it's really with student loans and mortgages, some auto loans. You might have been, let's say, 120 days late, and then you pay it. And so it shows a 0 balance, but they leave the current status 120 days late. Well, that typically is a violation. Gets a little complicated. What if you didn't pay it and it was like sold to another person? It's a little different, but the easy one is if you paid your mortgage and they leave the status as 120 days late, that is not accurate. It should say, it could say you were 120 days late or you were a charge off, now paid. It might say paid in full, paid for less than full amount, but it's just deceptive and inaccurate to leave the status as 120 days late and not tell people, well, this was paid. Okay. And that comes from a case called MASIC, M-A-C-I-K. So these are, at least sort of in our world, known as MASIC cases. And see a lot of those with TransUnion, some with other companies, but it's definitely something to look at. Let's see, going back to the email issue, I did a certified letter to the plaintiff. Have receipt of that. Well, I'll tell you this, at least in my state, Alabama, if you did not file an answer with the court, but you sent an answer to the plaintiff's lawyer, at least the judges I know, and I practice all over the state of Alabama, I think they would be pretty furious if the plaintiff's lawyer moved for a default judgment saying, well, she never responded. And then they found out that they were sitting there holding a copy of your answer. They were very upset about that. And, it's been a lot of maybe 20 years ago. It's not exactly the same, but I had a company that they were talking to my client before she was my client. And they said, don't worry about the deadline to answer. We're negotiating. You're good. And then 2 days later, they filed default judgment. Well, we went after them. It's like, you lied to her. You knew this was unfair. You knew we'd filed an answer. I've sued a company here. It's pending right now. We filed an answer with the court, and the company got it. And 6 weeks later, they filed a motion for default judgment and swore under oath in an affidavit that we had never answered, even though they had a copy of our answer. It's just a really, really, really bad look. And I was recently in federal court. Somebody had sued a debt collector and filed for default judgment and had actually received a copy of the answer. And federal judge just was not happy about that at all. Okay. So I would certainly bring that up that, hey, the plaintiff knew that I had filed or that I had submitted an answer to them. This is dirty pool. I wouldn't necessarily put that in the motion, but just sort of that's the idea. This is really underhanded. Now, it could be the court entered the judgment on its own, but almost every court I know of, they want the plaintiff to say, we haven't heard from the other side, enter default judgment. So I think that would be very helpful to you. Let's see here. We should refer to other lawyers that are local or take my case. So, just reach out to me. Let me know where you practice or where you live, and I'll see if I know somebody there. Let's see, Jared says, can a county-owned hospital that has made a debt set-off claim against husband-wife's joint tax return be taken if the wife disputes via certified bill is levied in the husband's name? That's... So what we're talking about is like you go to a government hospital, they say you don't pay the bill, and then they intercept your tax, your state tax refund. Sort of like if you owe a federal debt, like a federal student loan, they can intercept your federal tax refund. I don't know the short answers. I don't know if the debt in one person's name, if they can intercept the joint tax return. I think they have a mechanism maybe to say, the sort of the innocent spouse can notify us and maybe like their portion of the refund would be protected. So I just don't know exactly on that one, Jared. Let's see. Eric says, how can I prove I did not receive a dunning notice from a collector within 5 business days after their first call? That's put in the mail within 5 business. So yeah, it's put in the mail within 5 days. And the problem is they don't have to prove you got it. They just have to prove they mailed it. And you saying you didn't get it doesn't absolutely prove they didn't mail it. So it's a hard one to prove. We've done it before. It gets a little complicated. You have to say, sort of, here's my procedure for receiving mail. It goes to the left side of my counter in my kitchen, and I go through it carefully, and I don't have problems receiving my mail. I didn't get this. They must not have mailed it. And if it didn't get returned to them, that's an issue. But I will tell you this, Eric. There's an interesting case from the 11th Circuit that may get changed. The industry is going crazy over this case. They're trying to get the court to change. It says if a collector sends your information out to a mailing company, which most of these guys do, that's a violation of the FDCPA. So if they claim to mail it to you, like if you call them and say, send me a copy of it, and they do, and sort of the clue is, I don't have it right in front of me. I want to say it's like Culver or Carson, California. It'll be a California address, even though the debt collector's like in Virginia. It's a mailing house, most likely. You can send it to me. I'll look at it. But you may be able to sue them for that, even if you can't sue them for not sending it within 5 days. So let's see, Muriel, thank you for sharing your knowledge. You're very welcome. We're happy to do that. Oh, so Eric says, I got a call on the 24th, received the letter on the 7th, letters dated 25th. You know, it could be that slow.
But if it's dated on the 25th, then they mailed it the next day. So
yeah, now,
it'll be okay.
I mean, I have caught companies that will print it and they'll postmark it and then they'll hold on to it for 2 or 3 weeks. And, when we can prove that, we've got a case. But, so the key is them mailing it within 5 days, not you receiving it within 5 days. But now you got the letter. Look and see what the address, like if you want to send them a check, see if that matches their business address. If it doesn't, you may, depending on where you live, if you're in the 11th Circuit, Alabama, Georgia, Florida, you might have a case there. Okay, we're going to try to run through these, finish up these last 3 comments, and we'll let everybody go here. So Virginia says, can there be any credit reporting on a closed account other than the fact that the account's closed? So, Stephen, can they report a balance? Can they update it every month if it's a closed account?
If it's closed and paid, then that should be a final status, and there shouldn't be any further reporting. It depends upon how it's closed, right? Like a credit card can be closed for charging purposes. You can't charge it anymore, but it can still have a balance. So, but if it's closed with 0 balance, that's what's considered a final status, and there should be no additional subsequent reporting.
Yeah, that's right. So let's see here. Well, okay, if someone is sued for $5,000 credit card debt, small claims, is it best to answer them before the hearing, try to settle? It's Bank of America's plaintiff. So I'll say this. It's not impossible to beat an original creditor, but it's harder to beat them. A lot of judges will say, Stephen, did you have Bank of America credit card? Yes, Your Honor. Did you use it? Yes, Your Honor. Did you pay it off? No, Your Honor. All right, judgment for Bank of America. With the debt buyer, they think about it a little bit more and say, okay, well, can the debt buyer prove this? So what I would do is talk to a lawyer in your state that does this and just see, should I try to settle this on my own? Should I hire you as a lawyer to settle it? And I want to say you're in Georgia. So talk with Steve Koval in Atlanta, if I'm remembering right that you're in Georgia. Talk with Steve Koval, great lawyer in Atlanta, and ask him, and he'll give you an honest assessment. Does it make sense to hire him? Should you do it on your own? What should you do? And then, okay, yeah, so you had the Replevin with Toyota. I remember you asking about that before. They settle for less. And so that's great. And you certainly can do that with Bank of America. I would just talk with a lawyer to see if that makes sense with Bank of America. Have you ever seen a case successfully dismissed? This would be a collection case. Defendant shows up, case management conference, plaintiff does not. Is it worth a try? Yeah, I would try it. And depending on the judge and the court, they may say not showing up to that gets the case dismissed. Probably it'll be dismissed without prejudice, which it's not a full victory, but hey, it gets rid of the case and they have to sue you again. So better that than, potentially losing. So I would at least try that. And our buddy Eric says, thank you guys. Well, you're very welcome. Very good questions. Virginia, thank you for your help. You're very welcome. So this will be our last question. David says, debt validation letters not responded to in 30 days or is supposed to remove an item from the credit report. It's a very, very good question. So Stephen, we talk about that 30-day window after you get that 1692G letter and you dispute it, request validation, and they don't do anything. This is factual. They cannot collect against you. They can't call you. They can't write you. But can they continue to credit report?
Yes.
It is so annoying that you answer that way, especially because that's correct. And it doesn't make sense. If they can't call you, they can't write you, they shouldn't be able to credit report. But
they're supposed to update it as indisputed, right? So that's kind of the mechanism of the FDCPA. So because they kind of consider that credit reporting isn't debt collection, but the FDCPA says if it's disputed, they're supposed to notate it. So if they continue to report, but they don't note it as in dispute, it's on like Donkey Kong. Send it over to John. Wait, it's like backwards. Send it over to John.
So that's 1692E8. Now, two things about it. One, they have to update. Okay, so there's no obligation under the FDCPA to update and mark it as disputed. But if they do update, they must mark it as disputed. So what if they just sort of freeze it? Well, then we use the FCRA and we say to the credit bureaus, hey guys, Metro 2, Stephen's favorite topic, Metro 2 requires a furnisher to update, unless it's a paid account, every month. They're not updating it. It's unreliable furnisher. Get rid of them. And so it may come off your report, or it may force them to update it. If it's not marked as disputed, then something about Donkey Kong and 1692E8. So that would be good. And Golden Gate says, appreciated, and you are very welcome. And we are happy to answer questions. So my partner in crime here for legalese, Stephen, I think my voice is about gone, but we had fabulous questions from people, so thank you so much.
$2.5, my goodness. Well, my voice is still gone from CreditCon. That's why I sound like a dying horse over here. I'm trying to get it back over here. It's so much screaming and yelling, and my goodness. So, but good stuff. So, how can people get in touch with you, John, if they want to reach out? What's your best way?
Yeah, so alabamaconsumer.com is the best way. Me, and let me put one of those on the screen here. And then for you, Stephen, I know we've got
so if you want more information on the training course that we have, it's $99 a month. John is an esteemed attorney that's in there as well. We have a 30-day free trial. You can go to creditrepairtrainingcourse.com. And the brand new Metro 2 factual dispute letter software that we just launched this week. You can go to palmierisystemdemo.com, and I've got an awesome 2-minute video that walks you through that. It'll actually help generate those letters with the credit data in the letters. Nobody else does it like that. So that would be palmierisystemdemo.com. Yeah, and I guess that just about wraps us up, huh? My goodness.
All right, brother. Hey, good to see you the last few days, and it's like 4 days in a row. It
is. So, my goodness, I'm going to go through withdrawal here tomorrow because I'm not used to not going a day without seeing you. But appreciate everybody for watching, and I guess we will see you.
Let me just say one last thing. So next Thursday in the training group or the community Facebook, it'll be, is it you and Doug as
Me and Doug Miner. We do the expert witness show.
Okay.
Yep.
So everybody can tune into that, and then we should be back, I guess, 2 weeks from today, unless something unusual happens, and we will see everybody later. Y'all have a great day.
Take care.